All right.
SJC-11760, Ricardo Barbosa v. Commonwealth.
Good morning, Mr. Barbosa. And
I am present before the full court.
You're before the full court, and if you have your 10 minutes, and the clock has begun to run. So you may begin, sir.
Justices of the full court,
We're here.
I am not new to this, but I am true to this. All I have in prison is my word, and it is something that those, when they receive it or hear it, when I give it, can collect interest on it. For it is real like gold, and it is full of truth. I don't break it for nothing or no one. It will be like that till I have no breath in me. I am a convict true, not some measly inmate or a resident, and I promise to return to trial if this court release me on a 10% cash bail I have on my personal recognizance, with the probation department as surety and GPS of 24 hours house arrest, with the request for movements and appointments. I have presently $1,000 cash in my account, along with another 1,000 cash in credit on my credit account.
Now, the issue before the court, Mr. Barbosa, is whether the judge abused his discretion in setting bail for you now at $20,000. So if you would address that issue, please.
The judge has lowered the bail to $20,000, but I am a layman of the law. I cannot afford $20,000, but the issue is not about if I can afford $20,000 cash or not. I'm asking the court to release me with what I have personally, and I ask that the court put as surety the probation department as surety, along with any modification that the court chooses to do, GPS, home confinement, whatever it chooses. I can assure you that my bail has never been forfeited, nor would I want to lose my $2,000 cash of the 10%. Every other state in New England has a 10% bail bondsman system, and a lot of states throughout the United States has a 10%. If I was in Atlanta, Georgia, I would be able to provide the 10% system. But in Massachusetts, under the Bail Reform Act, did away with that in 1984 with the bail bondsman system. And here I am languishing in pretrial detention in the super maximum prison without being able to be afforded the $20,000 cash bail. It is like a slap in the face to be able to sit here and languish in pretrial detention and not be able to afford $20,000. The court very well knows that I had 2 jobs and can't afford a $20,000 cash bail. The issue is not mute. I have not been adjudicated convicted, so it is not mute. The district attorney has cited that the issue is mute because they have reduced the bail to $20,000, because I personally corrected the error that I was not facing life imprisonment, but a maximum penalty of 20 years if convicted. They turn around and offer me a 4-year sentence. And because I filed this brief, now they have raised that offer to a 7-year penalty. 7 years to plead guilty to this when I went before the court on April 15 of 2016, because I filed this petition. They raised the offer. They reneged on the offer. I went before Brassard again on April 15th and tried to plead guilty to the 4 years, and the DA reneged on the offer and raised it because I filed this petition. So it's another abuse of discretion, but not before Brassard. The abuse of discretion now is on the Commonwealth. When they're taking this new habitual criminal law, and the executive branch is abusing their discretion with this new law. And regarding the justices of the opinion, when they sent their opinion to the legislator, when they promulgated this new law in 2012 of August, when Governor Patrick signed this new law into place, they're doing away, and I speak on behalf of all tens of thousands of convicts on this bail reform, this new cash bail of Mass General Law 276, subsection 57. I speak on all of class of inmates held under this bail situation that I am faced with, that's languishing under 52A, which is another abuse by the executive branches. Throughout Massachusetts, without this opportunity to bail out on a cash 10% bail. I have to sit here and not be able to go to my 17-year-old daughter's graduation. And the district attorney's office takes my words on my brief and twists it around and goes to school and lies and says that my mother disowns me. I have 2 letters here yesterday, and my CPO can vouch that my mother sent me money yesterday. And she's been sending me money every single month. My mother has the money to bail me out. She has 3 homes. She has not disowned me. She refuses to bail me out because I keep coming back and forth to jail. But she does have money for a lawyer. I refuse to put money for a lawyer because I'm not guilty of this. Why am I going to put $20,000 for a lawyer? I'm not going to spend $20,000 on a lawyer for a crime I did not commit. I want the justice to release me. I can assure you that I will return to court. Due to the witnesses I have to gather, the attorney I wish to appoint for my trial, get my daughter situated into college and my children set up for school in September, along with my wife and home family life situated, I believe I can utilize the summer at home and preparing for my trial in September, rather than sitting in this dreadful unit, stuck with no possible movement or access to the law library, contact visits, barbershop, and I'm vulnerable to pick up more cases at the whim of the DA's office in subsection 52A in me here, recording my calls, recording my prison movement, hoping that I get assaulted here or I assault another inmate for the sake of another prosecution for them to further enhance me. Already lying alibi that I'm a danger and I'm violent, I'm a habitual criminal, I'm this, when the truth of the matter is, I haven't committed a crime in the community in over 14 years. It's due to the set-up probation regime that the revolving door of recidivism has them in business. And they've stolen 24 years of my life. Not because I'm a habitual criminal. That's absurd. They created this 28-page record through probation and paroles department through my foolish disregard and respect for them to impose and stoop their will on me. Now I'm already 40 years old. But I put away these childish ways. I've done it so my children don't have to suffer anymore. I want to ask the court to be released and lower my bail. I promise you, I give you my solemn convict word. That's all I have left. I will show up for trial. I will be there. Whether I have to suffer another 20 years of my life, I'm prepared to go to trial as a just man, as not guilty till I'm found guilty or not guilty. Not I'm guilty until I'm found not guilty. That's what the Constitution of the United States says. You're innocent till you're proven guilty, not vice versa. Massachusetts got it twisted. I say no more. I rest my peace.
Mr. Barbosa, do you have appointed counsel in the underlying rape case?
Absolutely not.
What happened to your counsel? I thought...
He lied and then he withdrew.
Okay.
He
So
shared all the secrets of this case and then he withdrew.
so he was appointed by the court?
Yeah, he was my attorney for a whole year. He didn't file not one single motion, and then he withdrew.
Okay, have you...
And my first attorney was a great attorney, and the Commonwealth forced her to withdraw. She withdrew on her own initiative.
And have you asked the court to appoint new counsel for you?
I am without counsel right now. I just spoke with Don Bernstein a few days ago, and he told me to call Beverly Trevajian to get an attorney.
All right, so you're taking steps to have new appointed counsel?
Yes, I have to, Your Honor. I have to write the court and ask them for a status hearing to be appointed counsel. I'm no fool. I can't go to trial without counsel, Your Honor.
I understand that. Okay, thank you. I'll hear now from Mr. McGee from the DA's office.
Good morning, and may it please the court, Michael McGee for the Commonwealth. Where the defendant's bail issue was addressed and reduced by the Superior Court while this appeal was pending, the appeal is moot. The issues raised by the defendant are such that they are capable of full appellate review before they become moot.
Well, then it's not really moot. I mean, he's asked for personal recognizance, now asking for a further reduction. So just because there was a modest reduction at some point doesn't mean his bail petition here is moot.
It's an issue, I would suggest, that was addressed. His major issue here is that it was he felt that he was faced, the bail was set because he was facing a life imprisonment, a mandatory penalty, as opposed to 20 years. That issue was addressed by the Commonwealth with the Superior Court judge.
So what is he facing? He's charged with rape and being an habitual criminal.
Correct.
So
20
what-
years.
What?
20 years in state prison.
20 years.
But his argument is whatever it's set now at 20,000, I think his argument is he can't pay that. So whether it's 25 or 20 doesn't change the argument.
Correct. On the merits of the issue, the single justice, I would suggest, was appropriate in denying the petition because a Superior Court judge has an inherent authority to deny, admit, set bail, to reasonably assure a defendant's appearance at all future dates. Here, there are a number of common sense factors that a judge can consider. Here, this defendant was on GPS monitoring. He was under parole supervision when he committed the rape. After he had ingested K2, a synthetic marijuana, he admits in his brief that he has a lengthy criminal history where the judge read that, it took 15 minutes for him to read that in open court. He has admitted mental health issues. He has limited or no ties to the community, uses drugs, and as I stated, faces a 20-year mandatory state prison sentence. All of that, I would suggest to the court, was more than enough for the single justice to deny the defendant's petition.
A couple of collateral questions. He's at Sousa Baranowski. Why is that?
I'm not completely sure of the details. I can
I mean, he's only being held on bail, right, at this
correct.
point?
I can represent to the court that his board of probation history includes a assault and battery of a correction officer where he served 3 years to 3 and a day in state prison. I don't know if that had anything to do with why he was transferred from one prison to another.
All right. And the other question he raises in his brief and also in a recent filing he just made, that he somehow is seeking the return of his property, $27,000, and the Commonwealth was directed to look into that. What's that all about?
The defendant was courtesy booked by the Quincy Police.
Excuse me?
He was courtesy booked, as the
All right.
phrase, by the Quincy Police. The defendant believes that as a result of his arrest, he wasn't exactly arrested, he was taken on the parole violation. He believes that $27,000 went missing. The court ordered that the prosecutor take the order to the Quincy Police and return $27,000. That money was never taken, was never.
So has your office reported that to the court?
I don't know if they've reported to the court. I know that they've addressed it with the Quincy Police, and that money was never.
How about with Mr. Barbosa?
I can't represent that to the court. I don't know what discussions took place in.
I mean, has there been something in writing that he can see what was the fruits of that investigation?
I know. I can address that with the prosecutor that's handling it at the trial level and make sure that Mr. Barbosa has a definitive answer on the $27,000.
Thank you.
And he also mentions that a plea offer was withdrawn, he claims, to penalize him from having pressed this appeal. Are you aware of that? Do you have any view of that?
I don't know the veracity of that statement. I would suggest to the court that.
Apart from the veracity, do you have a view as to the propriety of doing so if it were to be true?
My view is that he was offered, my understanding was that with counsel there was a discussion of a plea. It was rejected in court specific to this case and to actually concluding a plea. The defendant, as you've heard today, claims innocence. I would suggest to the court that it's very difficult to complete a colloquy when you have an individual that will not admit that he did the crime.
Well, that may be, but is it correct that there was an offer for a sentence of 4 years that has now increased to 7?
It was not increased to 7. There was an offer of 4 to 4 in a day, I believe, and that was rejected. And I believe since that date, another offer has been presented, was presented in open court to the defendant. It was not 7 years. I believe it was less than that.
Sorry, rejected by the court or rejected by Mr. Barbosa?
Mr. Barbosa.
All right, but you still haven't answered the question again, I don't know, and I guess you do not know, because you're not the trial prosecutor.
Right.
But speak to whether or not it would be appropriate if the motivation for the increase in the offer were his prosecution of this appeal.
If the motivation were the prosecution of this appeal, I believe that would be in bad faith, but that was not what happened here, and I would suggest to the court that
You say it was not what happened here, but you don't know what happened here, so.
I can tell you that I'm handling
you're
the appeal, and
Okay, so certainly it didn't come from you.
it certainly didn't come from me,
Okay,
is what I'm saying.
but it's also fair to say that if that were the motivation of the trial prosecutor, which neither you know nor I know, that would be an inappropriate thing to do.
That's a fair statement.
Any further questions?
Just to clarify, you said you didn't know that it was 7 years, but you do know, I assume, because you didn't suggest otherwise, that it is an increase, so somewhere between
It is.
4 and 7.
Yes, I believe what was represented was a 5 to 7.
Okay, thank you.
And maybe that's where the defendant got the 7 from.
And do you know the reason why there was a change?
I don't.
And do you know how long he's been without counsel?
April 15th of this year.
Is there another date set for appointment of new counsel?
I don't know when the next date in court is.
He has a trial date in September, as I understand, so that needs to happen pretty soon.
I would expect so.
Were there changed circumstances that justified an increase that you're aware of, changed circumstances that you're aware of that would explain why it went from 4 to 4 in a day to some higher number?
I'm not aware of that. I can tell you that the case against Mr. Barbosa is very strong. He was on a GPS bracelet.
Yeah, but it was strong when he got the 4 to 4 in a day recommendation already, I assume, right? So what changed?
There's a lot of factors that go into why a prosecutor might even start with a certain recommendation, but I can't speak to why the prosecutor in this case.
Well, there's nothing wrong with withdrawing an offer and making another one, except if it's motivated by something that we've recognized as being improper, and certainly pursuing a bail appeal would not be a proper motivation. So perhaps there were other motivations you might want to inform the court subsequently?
I'm not aware of any motivations. All I can say is that
You could make inquiry, however.
I certainly could.
That would be great.
And I didn't.
But you should, perhaps.
I absolutely will.
Thank you,
All right,
counsel.
thank you.
Thank you.